Did it say recording in progress for you?
It did, and I hit the got it.
Okay, so I'm gonna just do, let's just count down, and I can edit it so there's no problem. All right,
Okay.
3, 2, 1.
Hi, everybody. I'm Marci Hamilton. I'm CEO of Child USA and a professor at the University of Pennsylvania, and I'm delighted to be here today. Thanks so much to APSAC for organizing this and also for asking me to be a part of it. Uh, so as you can see from the first slide, the opening slide, I'm going to talk about child sex abuse statutes of limitation. But what I'm really going to be talking about is the complexity of the movement and also a couple of the side issues that have come up as a result of what's happening with respect to access to justice for the victims. So next slide, please. I'll be going through the national situation with the states and the federal government, but I'll also be talking about the international movement, which is now about a year underway in terms of a global task force working on it. Next slide. So the more I've worked on this, the more it's clear. SOL reform is an incremental process. It's been incremental for decades, but it's trending toward a zero tolerance position on child sex abuse. And so what we're looking at is a combination of three elements: civil statutes of limitation elimination, criminal statutes of limitation elimination, and window legislation that is open backwards and forwards. Now, so you can understand why there are three here, we can revive civil statutes of limitations for expired claims, but we cannot revive criminal statutes of limitations. So for the survivor that walks into the attorney's office and says, "I'm ready for justice," uh, in many states, their criminal statute of limitations would have been blown because the criminal SOLs were so short at one point. At one point, it was basically 2 years from the date of the act. So a 5-year-old would have had till age 7. Uh, and so then they find out that their civil claim is expired. You've got criminal and civil simultaneously expired. So what do you do? And that's what's prompted this movement for reviving expired civil statutes of limitations. And this has taken the form of what we call windows. So by a window, what we mean is we open up the window of opportunity for people to file civil claims. Typically, it's been 1 year, then it was 2 years, 3 years, 6 years, 5 years, but we have now landed on the concept of a permanently open window. And what that would mean is backwards and forwards. There is no statute of limitations going on into the future. So next slide, please. States, there's a tremendous amount of activity, and you'll get the flavor of it right now. Next slide. So this is a chart that shows you the pace of change for the civil claims. So we had since 2002, which is the marker, that was the first successful window passed, which was in California, and then was open in 2003. This is all triggered by the Boston Globe Spotlight report, because that report was the first time we saw the paradigm of children being abused repeatedly, priests having extraordinary access, and bishops turning away from it and doing absolutely nothing for the children. So if you start in 2002, what you see is, and this includes windows opening, and so that's 2003, the California window was open that we got past in 2002. And then you go all the way through to the end, the most recent. Obviously, 19 was our banner year, the most we've ever seen. But as you'll see, there's a tremendous amount of activity and a fair amount left to be done, particularly on the civil side. Next slide. So this is the map to show you where the activity has been. So the yellow states are the ones that have eliminated the statute of limitations prospectively going forward. The green ones are the ones where we have a window. We've revived expired claims. but they haven't yet eliminated the statute of limitations going forward. And then we have the states where they've done both. We've done both in Vermont. We have now an extraordinary bill in Maryland doing both, Montana, Minnesota. This is a map that shows you there is a lot already done in a relatively short amount of time, but a fair amount left to do. And the states that are left are challenging either politically or because survivors have not yet found their voice in that state, and their voices haven't made it to the state legislature. Next slide, please. So we rank the windows. Not every bill, even if it's reviving expired claims, is a great bill. Every single thing that we work on and get passed in our partnership with Child US Advocacy, which is our 501c4 sister organization, every bill we get past is sausage, of course, except if you look at A. The clean A are the states and the places, Guam, Mariana Islands for the territories, and Maine and Vermont for the states. These are states where no more will any victim ever hear, you can't go to court because you're too late. Maryland is a really great window, but it's the first one that has damage caps. There are generous damage caps, but this is a new flavor. They also were just insistent on not providing compensation for victims who had already passed away. So the estates, the families, the spouses of survivors that passed away were excluded from the Maryland bill. We still don't know which particular cases are being served by that, but of course we didn't view that as a great development. And then as you go down, you get down to some of the worst states. Sadly, my home state of Pennsylvania, Massachusetts, Rhode Island, Michigan, but each one of those is actively looking at window legislation this year. And I feel good about the strong prospects for each of those states. Next slide. So this is the chart that shows you how complicated this is. So we track every bill that gets introduced, whether it is an extension of civil or criminal, it's elimination of civil or criminal, or it's a window, or it's reviving claims up to a certain age, like in Massachusetts, it is age 53. So what I want you to see is both the vibrancy of the movement, but also the extraordinary incremental aspect of this. And I'll be showing you in each of the states where there's action this year, exactly how complex the picture is and how it is necessary to follow every state. Of course, we update all of our data every week. But before I move to the next slide, what I want to point out is, why do we need these windows? And with the windows and with the eliminations, we often talk about the survivors, of course. We talk about their need for justice, validation, empowerment, and all of those play into this. And we're, of course, totally dedicated to those. But also, and I'm increasingly persuaded, just as important is the fact that these lawsuits inform the public, lawmakers and judges in ways that open up not just the ability for survivors to get justice, but also the capacity to have a public conversation, for parents to understand that we are still not in a position to say that their children are safe in the vast majority of institutions. And a lot of that is due to the fact that we have such a high barrier to education, although we're all working on it in this room, is persuading the public and the parents that this is a pervasive problem. Your child, regardless of socioeconomic status, regardless of race or gender or LGBTQ status, your child can be at risk of child sex abuse in a variety of contexts. And so this is a massive public interest campaign as well as something that is necessary to help the victims. Next slide, please. So if you rank the states, what you'll see here is the criminal statute of limitations is where we've made the most progress. We have 44 states and 5 territories that have no criminal statute of limitations for some or all of the child sex abuse crimes. That is extraordinary. We're leading the world in all of this, of course, but we are right now fighting in UK and the EU, I should say the EU, to raise the criminal statute of limitations to 50 if we can. And of course, we're advocating for abolition, but that's a much harder call around the world than it is here in the United States. We have 17 states, 2 territories in the federal government that have no civil statute of limitations. The federal government is actually the best now. It has eliminated, in terms of elimination, it has eliminated the criminal and the civil statutes of limitations for crimes against children and for civil claims for crimes against children. But we don't have a revival at the federal level. All of those are at the state level. And then we have 26 states and 3 territories that have revived expired claims in some way. And as I said, sometimes it's just an age cap, and sometimes it is a complete permanent window that is open backwards and forwards. That is the most recent movement that we see. That's what we expect into the future. Of course, it's not going to happen overnight, but it's already the way in which people are talking about the need for letting victims into the courts, but also clearing the air for the public about what's really going on. Next slide, please. So this year we have activity in a number of states, and we also have a number of states that have already passed SOL change. This is Alabama. Many of the states in the last 2-3 years are ones that both I and Catherine Robb with advocacy would have said we'd be looking at in maybe a decade. Alabama, out of the blue, came forward. Why? Because of a survivor story and because of advocates going to their state legislatures. The pace of change is getting faster. The demands are getting stronger. Almost always we see now with an early bill in a state that it is the revival. It's the big kahuna. But often it does get scaled back to an age or just prospective. We'll see. Alabama is still in play at this point. Next slide. Florida has done a good job of forward elimination for civil and criminal. It's actually unconstitutional in Florida to revive expired claims. So we are working on getting a constitutional amendment starting next year. But right now they're trying to add other civil causes of action to include in the possible claims. So, these are for ages 16 to 25. It's really just another add-on to having eliminated it for some of the civil claims that are based on the criminal liability. Next slide, please. Kansas, this is a bill that has been talked about for several years. This isn't the year, but we do think we'll see something in the next several years. Next state, please. Maine. Maine is the bill, but here's where the pitfalls are. Maine is the state that has a permanent window. There will be no statute of limitations, but there's another barrier to the victims being able to get compensation and to be able to pay for the therapy they really need. And that is that they have a charitable immunity limitation. Charitable immunity is something that we brought over from the UK. It has been part of the common law. The concept is that you do not create liability for charitable institutions. Churches, therefore, cannot be sued under charitable immunity, or there's a very low cap on the damages available And so right now, Maine and Massachusetts both have that problem. It's There was a time when charitable immunities blanketed the country. Not so anymore because the logic of it, automatic immunity for harm you have done, has just washed away. And that's why we're now hammering on specific states that have some of this left to try to move it away so the justice is full and not just the organizations being able to close out claims, but not to help the victims in the ways that they need it going into the future. Next slide. Maryland, this is the one we're very proud of this year, permanent window. Uh, this was, I testified in 2003 in Maryland, and I walked out of the legislature and I said to myself, I will never testify here again, because it was 100% clear that the Catholic bishops owned the legislature, that there was no way that they were ever going to permit any kind of progressive window legislation in the state. And, we had other states to pay attention to. And the next window, of course, was Delaware. But what happened? So, what happened? The first thing of what happened is the keepers. When the keepers came out and there were spokespersons who were in the keepers, which is an extraordinary documentary about the death of a nun and the cover up. The victims of child sex abuse that were part of that story went public, and they were very impactful. And of course, the documentary was extremely impactful, not just in Maryland, but around the country. So movement started, and we started, maybe Maryland is something that can really happen, and have been talking to them for about 5 years, trying to get this moving. First, there was a discussion about, well, let's try to get a revival bill. And what happened is the Catholic bishops were very clever, and their lobbyist was able to get into a bill that was good for the civil statute of limitations, but no window. They were able to get into that bill and insert what they claimed was a statute of repose. Sorry for all the technical lingo here. A statute of repose is a statute of limitations, which, when it expires, it's over. You cannot revive a statute of repose. And so they thought they were clever. Even the sponsor had no idea that this was in the bill until it became public. So what they tried to do is they tried to plant a seed in an earlier bill that would completely immunize institutions, and especially the Catholic Church, for any forward claims if a window was passed. Fortunately for us, for the survivors of Maryland, the courts haven't read it that way. They have not read it as though it is a permanent barrier to any claims. So we do expect that the Maryland window will be effective and will not be stopped by that. But what you need to understand is that the forces that are against child sex abuse victims are all in. They are still spending millions. They are still motivated to make sure that as few victims as possible are capable of coming forward. And the primary opponents are the Catholic Church, of course, the Catholic bishops in every state. Think about it. The Catholic Church has a lobbying arm of its bishops in every state called the Catholic Conference. They live in the state capital and they are lobbying on abortion, of course. They're lobbying on gay rights. They're lobbying to get more funds for their programs. So they're already situated with many connections. So when a window is introduced, they fan out, and typically their argument is that there will be many false claims and they will go bankrupt. I'm quoting exactly what they say. Since 2003, I have been paying attention, and of course I started Child USA because I couldn't do this on my own. But we've been tracking false claims. And The truth is there aren't any. There are occasional false claims made, of course, that lawyers just aren't going to take because they're not going to pay for all of the costs of litigation if they've got a claim that's so weak and in fact they doubt the client. But more importantly, uh, there just aren't any in court. So they continue to lobby against Windows, and you can see how effective it was in Maryland, saying, "Oh, you're going to have so many false claims." Well, as they're saying that in the legislature, the many victims of the Catholic diocese and other entities are out marching, and so it's just not either credible or moral, but they continue to make the arguments, and I am pleased to say I have not yet heard a new argument. I have not heard a new argument in 10 years. So we've got the answers. It's just a matter of politics at this point and getting to the right people in the right environment in the state to do the right thing by the survivors. The insurance industry is paying the most money. The insurance industry contributes to both Democrat and Republican campaigns. They are a major force, especially on the right, and they lobby until they're blue in the face against these windows. And what they say is that there are going to be so many claims that the sky will fall, and the real upshot will be bankruptcy. And the bishops love that line as well. Oh, we're going to go bankrupt. What they mean by bankrupt is not what colloquially we mean by bankrupt. What it means is that they're going to go into voluntary bankruptcy and they're going to reorganize their assets so that they are better off in the future. And so the victims can only get pennies on the dollar. So I'm going to talk in a little bit about the federal bankruptcy reform that's absolutely needed in this space. But the primary two messages to block access to justice for victims across the country are false claims, which is false, and bankruptcy, which is intentionally misleading. Next slide, please. Massachusetts, another one where we're looking to open a permanent revival window. We expect some kind of activity there probably in September. Next slide. Michigan's exciting. There's a lot of activity in the middle of the year now. There'll be hearings sometime in the weeks of June 6th and June 13th. But we're looking at a good window. We're looking to remove the notice of claim and the sovereign immunity if we can in order to open up claims against public entities. That's a very hard lift in addition to an ordinary window. And we're looking for extensions on both civil and criminal. So all of these provisions have been introduced in the House. Now we'll go over to the Senate. There'll be new discussions, and we'll see where we land. But I think it's very likely that we'll see window legislation in Michigan this year and probably this summer. Michigan, of course, is the home of Michigan State. It's also the home of the University of Michigan. So Michigan State, of course, covering up Larry Nassar's abuses, and University of Michigan covering up Dr. Anderson, who was treating students and athletes and abusing them. So Michigan has had the flavor of window legislation. They passed a very short window just for Larry Nassar victims. That was very harmful and hurtful to all the other victims, in particular the religious victims in the state. We're now working to try to open it up for all the victims in the state. But it really took this education, starting with Michigan State, for the state of Michigan to understand why they would need a window. There was a time where they were the absolutely worst state in the country. They were the shortest statute of limitations, age 19, until relatively recently. What happens when you have that short of a time to come forward, and you know that the discovery social science tells you that victims need decades past the abuse to come forward. On average, based on our Boy Scouts data and based on our literature review, we typically say it takes till the average is about 50 to 52. And that, of course, about a third never come forward. When you have that scenario where the vast majority of victims are not capable of coming forward in a safe place in the courts, there is such a dearth of knowledge. So when I went out to testify on the Larry Nassar window, I was appalled at how little they knew about the incidents of child sex abuse and the ways in which the system was preferring entities that were covering up abuse and perpetuating more abuse, and how the system was silencing the victims. It's taken very hard work to get to the point where lawmakers are educated so that they will embrace these laws. And that's true in every state. It is the education, and it's not just the survivors' voices, but it's the education generally about prevalence, about trauma, about the actual impacts of trauma, and about all the arenas where child sex abuse can occur, whether it's school or extracurricular or church or sports or doctor's offices. It can occur, as you know, anywhere that a child is present. And for that reason, you have to work very hard to bring those up to the attention in a state where nobody was getting access to justice that was meaningful until relatively recently. So I'm particularly proud of Michigan, and I think the whole movement should be, because this is an opening this year that would have been inconceivable a decade ago. Next slide. Missouri is a tough state, and the bill was just killed to open up a window. The latest revelations about the Kanakuk camp, evangelical-based camp in Missouri, and then their other outreach camps, that really prompted a number of people to say, okay, it's time. The biggest problem in Missouri is an equivalent problem in Wisconsin and Utah. These are the last three states that still have state Supreme Court holdings that say that the First Amendment is a bar to liability. So you can't sue the church because it's a church. You can't sue the Latter-day Saints because they are the Latter-day Saints. So that kind of reading of the First Amendment, which is a privilege for religious organizations, typically was thought about decades ago. We thoroughly put that to bed and out of the picture in California and many, many states since. But these three states continue to have this wrong, wayward way of thinking about it. Now, we've asked the Supreme Court twice to overrule the leading case in Missouri that takes this approach. Court hasn't taken it yet. I actually think that we're going to see some softening in these holdings because of the irrefutable logic of SOL reform and the many people coming forward and showing how important it is to give them justice. So I don't hold out a lot of hope that the current Supreme Court will take the case. In future, we've tried, and I think at this point, we're going to be better off in the states. Next slide. So New York has been the place where we've had a plethora. We had the Child Victims Act, which took 17 years. I drafted it when I was still a law professor, and it took quite a while for it to get legs. But again, the education of the state was way behind, as it was in most states, and it took a tremendous effort on the part of many victims, many lawyers, and organizations that band together. It was an honor to be a part of that process. And what's interesting is at the same time so New York passed its Child Victims Act, about 3 years after New York started, we started working on New Jersey. New Jersey's window passed, but we snuck into it that it was good for reviving claims by both child sex abuse victims and adult sex abuse and assault victims. And why was that? Because there are so many similarities Now, children, just by their age and their brain development and their maturity, really struggle to come forward. They don't understand what's happened to them. They certainly don't understand sex in any kind of context that would involve them. And it takes a long time for them to put the pieces of the puzzle together. For the adults, what they share with the children is the shame and humiliation, and often the power of the perpetrator over them, whether it is the father or it is someone like Donald Trump. Uh, the Adult Survivors Act, we fully supported because we view childhood for purposes of our work from 0 to 24. Until the executive function of the brain is fully developed, there's going to be greater risk for an individual to be subjected to untoward uh, advances and manipulation by perpetrators and by institutions that let them operate. So it was wonderful to see the adult survivors being included in New Jersey. We went back to New York and said, "Did you realize New Jersey has a better bill than you do?" And New York promptly responded, "Well, we would like that." And so the Adult Survivors Act passed. It is the Adult Survivors Act in New York that is the reason that E. Jean Carroll was able to bring her claim. The Me Too movement encourages people to come forward and to make a public statement about their abuse. It does not by itself do enough. Victims who come forward and don't have the courts on their side can be subjected to defamation lawsuits. They can be subjected to pressure. They can be expelled by family, by organizations that they know and love. And so it's really dangerous, both for adult and child sex abuse victims, to be out there talking, but to not have the backup of being able to take someone to court. E. Jean Carroll, I think, is the best example right now of someone who was talking, but with Donald Trump on the other side, it had turned into a very public he said, she said debate. Now, you know, who do you believe? Uh, you've got a former president who lied for a living, but um, they both were in the space, and she couldn't claim victory by just simply telling her story. So the minute the courthouse doors opened, she was empowered to go in, and the judicial system and the understanding of the public about how this needs to be done came forward, and she prevailed against someone who was the most powerful man in the world as a president who intends to continue to run for president and who is capable with his misinformation of silencing just about anybody. So we're particularly proud of the Adult Survivors Act in New York, which never would have happened unless we had all of the research on delays in coming forward and on brain and development to make it just logical. If you've got a Child Sex Abuse Victims Act, you probably need to do that for the adults who are silent to the detriment of the public and who deserve compensation. We also, this is a first, a last. New York City has its own criminal code and its own laws. So there is a New York City window, which is going to be open for another year. So any abuse that happened in New York City of a child or an adult, that is going to be an open window for a couple more years. Pretty amazing. We're now talking to them about a permanent window. And then I might not go back to Albany, but don't tell them I said that. Next slide. North Dakota. This is a bill that was signed into law. It started with a really great window, but we ended up with a civil extension. We were able to get age 15 to 36. And, that looks great. But unfortunately, that's about 16 years short of the average. And of course, many survivors don't come forward until their later adulthood. So it's not catching half of the victims, but at least it's a step forward. And what that means is we'll just be back to push it forward again. And eventually, we hope to see a revival window and access to justice for everybody permanently into the future. I think it's inevitable because the logic is irrefutable that a window will be in place in every state eventually, but it's a heavy lift, and we're having to deal with and support incremental change to finally get to that point. Next slide, please. Pennsylvania, my home state, mired in politics. It's nothing but politics at this point. Republican, Democrat. Typically, you have a divide early on in which Republicans are less supportive and the Democrats are more supportive. But when you put these bills to the floor, they typically pass unanimously or close to unanimously. This is now in the hands of the governor, and we'll see what happens. Next state. Rhode Island, we're working for a window in that state as well. Next slide. South Dakota. We got a law passed in South Dakota, which is a very big deal. It's a small law. It broadens the crime of fourth-degree rape. So now you include rape without consent. And the SOL is either 25 years old or 7 years from the offense. The reason I want to emphasize South Dakota is many states, until recently, had these kinds of draconian laws, and there was no chance for the victims to get justice, and the public just couldn't learn about all of the risks for the children that are currently occurring in your state. So this is just a small step, but we're on the way. Next state. Texas, good luck to us. Bill was introduced this year. We hope to see maybe some hearings next year, if not more. Next slide. Washington State, again, not happening this year. We'll see more if we reintroduce next year. Next slide. Okay, so the reason I went through those tedious states, and if any of you are still awake, thank you. But the reason I want to go through those is to show you the on-the-ground necessary activity and work. For every single bill that's introduced, we are submitting testimony. We are, through Catherine Robb, testifying in person. We are answering questions, and we are providing all of the data that you need to be able to get these bills passed. We make it look easy, but it's a tremendous amount of activity, and I have an amazing staff to make it happen. At the national level, next slide, please. Last year, we eliminated the civil statutes of limitations at the federal level. When it was announced, you can't imagine the number of countries, the number of individuals that checked in and say, yay, how did you do that? How can you make that happen? And they all assumed it was retroactive. It's not. So the federal statute of limitations is the perfect. It's elimination going, but it's the imperfect because it's only going forward. I don't expect to see a big revival in the federal government, but I do expect to see, next slide, more bills that would incentivize the states, either through captive funds or new funds, depending on the bill that's introduced. The current bill that's been introduced is by Representative Wexton. There was another recent bill by Senator Gillibrand. Essentially, this is a bill that would compensate the states, encourage the states to get better statute of limitations laws by rewarding them with more money depending on how good their statutes of limitations are. So elimination of criminal, elimination of civil, window legislation. That's what we would like people to be looking for. That is going to be a lift, but we're in Congress working on it. Next. We now have a pending CSAM bill, I'm sure, as you all know, Child Sex Abuse Materials Bill, and it's highly complicated. It's about 140 pages, and we're working through it. We also have the Earn It Act, which we support. Um, these seem to be on a faster track than expected, and so we may well see, in fact, I expect to see movement this year on creating liability for Meta and Facebook, for Twitter, etc., for the harm they do. As Lindsey Graham said, it's time to get the trial lawyers just suing the providers and basically making them responsible. So far, they're acting with impunity, and when you have a victim who has autism and who has other debilitating diseases and who was sexually abused and is being attacked online by the followers of the person she has named, when you have that and you call Twitter, they do nothing. They continue to permit the gross um, and horrendous abuse of her to occur online. So right now, what's the option? Right now, the option is to not be online, to not connect with people who are on Twitter or the other services. And so it's a mess right now. It's a mess because there's been no liability, no obligation to be responsible. I expect some mix of these apps to change that and to open the door to sue for defamation and to sue for CSAM. Next slide. And this is another part of that universe. So I'll be happy to talk and answer questions about what's live when we're together. Next slide. So the bankruptcy system has been tailor-made, which is why the bishops love it. They have we've now seen about 30 diocesan bankruptcies, plus the Boy Scouts, plus USA Gymnastics. Why is it so attractive? First of all, it gives the ability public to say, we're going bankrupt. All these victims are so mean to us, coming to us for something that we shouldn't be held accountable for. But secondly, much more important actually, the reason that you see them going to Chapter 11 at bankruptcy, Chapter 7 is dissolution. We haven't seen that with child sex abuse. What we see is Chapter 11, which is the ability to reorganize. The purpose of Chapter 11 was to help honest business owners to move on from a situation of owing creditors and not being able to go forward. The idea is you help them reorganize assets, you pay off everything you possibly can, but you preserve the ability for the business to go forward. And in the end, you have saved the business. Why wouldn't the diocese jump into that formula? So what happens is you have the survivors coming forward with lawsuits, say a window opens, or you have a state that has its own decent law in this arena, which would be Oregon, for example. So you've got the lawsuits there. And so the response is to file for bankruptcy because it immediately turns the tables. It immediately says that now the debtor is the focus of the universe, and the whole purpose is to make sure you save that debtor and let them go forward and not have to deal with this anymore. And the victims, who were the righteous people who brought the lawsuits, are now mere creditors. Under bankruptcy law, they are no different than the roofers and the plumbers. They are then sidelined. They are told, sit down. We're now going to figure out the business deal that this organization needs to survive and be a healthier version of itself while you sit down. And under the bankruptcy law, your lawsuit is now stopped. You cannot continue to litigate against the bad actors and get the information you need to make your case or even to prove the value of your case. At the same time, we have a system where the debtors have been permitted by bankruptcy judges to get their affiliated organizations treated as though they are debtors. So the best example is the Boy Scouts. With respect to the Boy Scouts, you had the main organization filed for bankruptcy, but the assets were owned by the local councils in the states. They own the land. And so you file the BSA files with their limited assets and the real money where the real abuse was actually happening in the states. They are non-debtors, and so you should be able to go forward in suing them. But you can't, because bankruptcy law says those lawsuits stop. And at the same time, in the negotiations, the debtor, diocese, Boy Scouts, USA Gymnastics, says, well, I'm not going to reach a deal. I'm not going to pay what all of these victims desperately need. I'm not going to pay until you immunize from further lawsuits all of my relational organizations. So non-debtors do not have to reveal their worth. They do not have to reveal their assets as part of the bankruptcy because they're not a debtor, get to shield their assets. The main player, the BSA, gets to keep themselves from being sued forever, and they get to keep all their affiliated organizations from being sued again. It is a recipe. It is a beautiful recipe in the favor of the institutions and the perpetrators. It is ugly for the victims. So what do? So what you do is you amend the federal bankruptcy, Chapter 11, and you create a child sex abuse exception. And the child sex abuse exception says you may not immunize someone if they're not a debtor. If they are not declaring bankruptcy, they don't get the special protections given to debtors, number one. Number two, you can't stop the litigation. You've got to let these victims go forward, because what is it that these organizations want the very most? What they really want is to keep the secrets they still hold, right? Think of it as a business. You've got all these claims that have come forward, they're public, okay, but you don't want to, if you're the Boy Scouts, show the perversion files, the files that show how you permitted scoutmasters to move from state to state and get more and more boys. If you are a diocese, you do not want to show one more line of the secret archives that will show that you knew about even more abuse than any this total victims can attest to. So you have to let them go forward with the lawsuits. One of the things is perhaps you would do bellwethers. So you choose 3 cases, you try them. You don't do 82,000 cases, but in any event, some litigation must be done to reveal the truth and to create any kind of meaningful leverage on the part of the victims. When Chapter 11 is filed, the other advantage for these organizations is that they can they get the full benefit of the bar date. So typically, you file for bankruptcy and you want to make sure you can tie up everything in a nice bow for your debtor to get through the bankruptcy. Well, how do you do that? You say, okay, everybody has to come forward by this date, 6 months from the filing, 8 months from the filing, a year. I think it should be 5 years. But in any event, there's a very short time. So you force out victims whether they're ready or not. And then you're able to say that any future victims are really going to get a penny or two of what's left over from the negotiations over the ones you forced out. So the bar date, the ability to immunize non-debtors, and the lack of litigation going forward are hugely important for them. But the other category of harm in this universe is that victims don't have any say except a vote. They're given $1 as their value, and so they can file their vote for the plan. What they deserve is public victim impact statements. And so we are also saying, look, if you're going to let child sex abuse be a part of Chapter 11, you need to make the first 2 changes I mentioned, but you also have to give these victims a day of victim impact statements, or a week, or a month, so that publicly they can feel like they matter and the public can learn the truth. And it needs to be done before the plan is confirmed so that the Boy Scouts, the dioceses, the USA Gymnastics, so that everybody knows what they did. Um, so, so those are three simple things, but there's a super simple fix that we also need. Right now, the Boy Scouts, the dioceses love to request uh, secrecy for all of their files, and they ask the courts to seal their evidence of their bad wrongdoings, and courts have been granting that. The Boy Scouts are not going to have to reveal all of their files. The dioceses typically don't have to reveal all of their files. They can keep secrets for any set of evidence they want to when they get these sealing orders. So that needs to be taken away as well. So it's a complex situation which has burst onto the scene. The bad actors are ravenously gobbling up being debtors in Chapter 11, and we're working very hard to persuade both the public and lawmakers this has to stop, and you've got to quit treating the victims this way. The flip between you're the center of the lawsuit and you're the one who's righteous to being a mere creditor is simply cruel. And the whole system is unfair. Next slide. I'm going to go quickly through the what's happening internationally, but I think you'll be interested. Next slide. So, Child USA now has a subdivision, Child Global, and we and the Brave movement, largely based in Europe, we have put together the Global Statute of Limitations Task Force. So we are putting together, Child USA is putting together a dashboard of access to justice in every country in the world. We've already done this, of course, for the United States. We will be publishing a report on the statutes of limitations in the Americas, probably September of 2023. We're then moving to Europe. We'll then be moving to Africa, and then we'll be moving to Asia. This is a minimum of a 5-year project, but we will then continue to monitor it just like we do with the states. And we're already in conversations with the EU. So, so what we built here in the United States is the basis. All of the survivors that worked on this, all of the lawmakers, the millions that made all of this happen in the United States. The world didn't miss the model, and the world is now moving. Now, what are they looking at most closely? Elimination of criminal statutes of limitations. Civil is going to be a harder lift because of all the different ways in which other countries compensate victims. But if we get, and we will get, we're already getting criminal SOL change, we're going to learn a lot more, and the world will become smaller and smaller and smaller for those who sexually abuse children and the institutions that sanction it. Next slide. So this is the board or the task force board. I am really honored to co-chair it with Miguel Hurtado, which many of you may know. He's a leader in Spain. He's a survivor. And we are really happy to be working with the charter members. So next slide. Okay, so the most important thing that we do is keep track and keep people honest, and keep these the research going. Here are the 3 places you can go to find out what's happening on any day of the week. If you go to our homepage, childusa.org, or you use this QR code, we do every year we have an SOL tracker. It tells you every bill introduced, the activity on every bill, it ranks every state, and it tells you what's happening in the state if there's not yet passage. We also do an annual SOL reform report. This is the history of the statute of limitations per state in the federal government and the territories. It's usually published in June. It will be out this year in June. And it's actually fascinating because what you see in every state is exactly their incremental development. And lawyers need it extremely, because if you don't know what the statute of limitations was, the date of the abuse or the date coming forward, and how to judge which one applies, um, you're in trouble. You need this. So we become the resource for that. And then the Global SOL Reform Task Force. We do have South and Central America already. The United States and Canada added soon. Of course, the United States is just a link back to what we've done. But I hope you'll see this as a massive movement for survivors to get their voices heard in safe places, and to be able to fix, literally fix the legal system, so that healing can start, and so that everyone in this room can do what they're doing with even more strength, because we're no longer dealing with the darkness that the other side would like us to live under. Thanks so much. And next slide. Happy to answer questions when I get to you. And next slide. This is the QR code for the so-called Hamilton Library. Thanks to my staff for putting my name on it. Any $1 million donors out there, happy to put your name on it. But we have a child sex abuse library, which is aimed at educating teachers and lawyers and clergy and others about these issues, suggested readings. Please take a look at it. And if you have a publication that you would like, that you think should be there when people are going to look for what they need to understand, please send it to us. We would love to add it and give full credit. And if you know of publications or books that we should add, please send it to us. And going into the future, please do so as well. This is a safe library for survivors to go and poke around and see what they need to know, and see what they can handle, because a lot of it is difficult, but they have to click on it to read it. So any suggestions on the Hamilton Library, all ears, and thanks so much for having me today. Take care. So how long is that?